Andrew Weissmann, you've just issued a tantalizing and newsworthy tweet in your own right with your credentials, with your relationships and your expertise. I'm going to read it to our viewers. Quote, a zillion stories about Trump case, but bottom line is that he's getting charged and it will be in D.C. and this week. Open issues are whether others may be charged and whether they will be in D.C. or Florida. Please explain.
Sure. Well, first, it is really typical to see what we are seeing in terms of Donald Trump's counsel going to the Department of Justice. We saw the same thing when we were looking at the Manhattan DA's office. That is that prosecutors in cases like this, where there's no need to nab the defendant because they're in the middle of committing a crime or a violent crime where they're fleeing, they give defense counsel an opportunity to be heard and to make any and all legal, factual, discretionary arguments as to why there should not be charges. And so here, especially if the reporting is about the attorney-client privilege, I mean, that's just never going to stop, anybody from, finding that the charges are appropriate, because here a judge has approved what it is that happened here. And I should point out the current Solicitor General of the United States worked on the Mueller investigation where the exact same thing was done in front of the exact same judge. So I just think that's going to be a loser. It may be something they're arguing in order to make a political point later. And so we really are seeing what I always view as the harbinger of, cases being brought. So the exact same thing happened in Manhattan, which is you see defense lawyers making an argument and then you see charges. The open issue is where the charges will be brought and who, if anyone, may be charged alongside Donald Trump. In other words, there may be conspirators. There may be those charges may be ones that can only be brought in a different jurisdiction because there's constitutional rules about where charges can be brought. I should say, in spite of my tweet, it is conceivable that Donald Trump would be charged in Florida and not D.C. I don't think that'll be the case, but I do think the one thing I'm pretty confident of is that we are going to see charges with respect to the classified documents case. And it seems by all accounts it's going to be this week, because I think that the DOJ will feel that internal pressure to move this along.
I have 378 follow-up questions, but I'll start with one. What I think you're articulating is that the auspices of the meeting to battle the piercing of attorney-client privilege may be a Trump-driven errand because the matter's been adjudicated. The matter in secret, not something we saw. Evidence has already been provided that was strong enough that a judge said, oh, yeah, oops, yes, crimes, yes, crimes, yes, crimes, and that's why we get to see everything. Is that how I understand what you're articulating?
Yes, and Nicole, it's really important to remember. So there is a model for this having been done with respect to Paul Manafort and Rick Gates in the special counsel investigation. Before Beryl Howell ruled in that case, Manafort and Gates and their counsel all had an opportunity to be heard. In other words, this isn't something that's done ex parte. They all get an opportunity to argue why the government is wrong. So this has been fully litigated. There's no question that Donald Trump, as the person who holds the potential privilege, would have that opportunity to be heard. And so this has all been vetted by a federal judge, a respected federal judge. And I'm confident if it follows which it should have, the exact same plan that was done and the reasoning that was done by the judge in the Manafort case, this is not one where the DOJ is going to second guess what Jack Smith did or what the judge did, because it's all been vetted. So that just seems like a real loser. I think they may have made arguments based on venue. I mean, I know that sounds like a really weak T in terms of like, we're going to get charged, but can we please do it in Florida, not in D.C.? And I do think that Florida would be a better venue for Trump than D.C. So he may have made that argument as well.
What does it mean that a grand jury in Florida has heard evidence? Does that, us lawyers were spitballing, which is always dicey, and wondered if perhaps some of the early reporting about how every single person at Mar-a-Lago, including maintenance staff and including people that work on the grounds, has been interviewed, that maybe it was a convenience, but maybe that's a crazy, stupid way of thinking about it. Could that grand jury there have been convened for something else?
So just, Nicole, you shouldn't feel too bad because a lot of lawyers do a lot of spitballing also, and we can get it wrong as well. So, it's not unique to non-lawyers to be doing this sort of educated guessing. I think there's sort of two possibilities with respect to what we're hearing about there also being a Florida grand jury. One possibility is that all of the charges against Donald Trump will be brought in Florida. It seems by all accounts there would be venue for all of the charges. And just to be a little bit of a nerd, the Constitution requires that a crime be charged where it occurred. But a lot of times crimes happen in many, many jurisdictions. For instance, if you have a conspiracy charge, that could happen in many, many different locations. And any one of those would satisfy the Constitution for being brought in a location where the crime occurred. But there's no question, I think, that from everything we've heard, that Florida would be a place where all of the charges could be brought. And D.C., it's not clear that in Washington, D.C., all of the charges could be brought, but I think some of them could be brought there. The other possibility is that the reason we're hearing about a Florida grand jury is that it's not so much with respect to Donald Trump, but it may be with respect to other people. So, for instance, if an underling like Mr. Nauta, who is somebody who allegedly moved boxes for Donald Trump at Mar-a-Lago, if he made false statements to the government in Florida, that is something that maybe uniquely be charged in Florida, so that if the government is thinking, I'm going to charge Donald Trump in D.C., they may at the same time decide that they want to charge Mr. Nauta to put more pressure on him, and also because he should be held to account if he lied to the government, and that charge may be brought in Florida. So that might be a second reason for why we're hearing that there may be grand jury activity in that state.
All right, Andrew, I have one more for you. It felt like Jim Comey's, payout from the political grave, Lordy, there are tapes, as Michael Cohen before him and Don McGahn with his copious notes and the notes of his note-taker, Annie Donaldson, who became the narrator of Volume 2 of the Mueller report. Trump has another lawyer who didn't just take notes, but who narrated a, novel-like version of his month-long legal service for Trump. Is that normal?
No. So, when I think about the lawyers and the caliber of lawyers who have represented presidents of the United States, whether Democrats or Republicans, I don't think that is normal. And that's not either the caliber of the lawyers that we've seen. In other words, usually these are the people who are the most revered and at the very top of their profession. Think David Kendall or Bob Bauer or Kathy Rumler, people who are just, at the very top of their legal game. And there's no reason, whether you're representing George Bush or Barack Obama or Joe Biden, to be taking copious notes because you're concerned that your client or the president of the United States or the former president of the United States is going to be lying about what happened. But we know from starting, as you mentioned, with Don McGahn, that if you are representing Donald Trump, it is a good practice to take notes so that you have a memorialization of what you did do and what you didn't do to protect yourself from these kinds of claims. So it is really abnormal. And these are lawyers who realize what they need to do in order to protect their bar license with respect to a very difficult client.